I don't know, Judge, I'm reading a book.
I'm reading a book too. Actually, I'm reading 3 books.
Me too. Because scary movies is not cutting it up for me, so I'm doing the book.
Ah. Hi. So we have 100 applicants for court reporter. Yes, so I'm interviewing 100, over 100. I'm like, interview everybody. No, but you know what I always say, if somebody took the time to apply, then the least, yes, the least I can do and others can do is, yes. Oh, gosh, yeah. Thank you.
How old it is? How old, yes.
Good morning. Deputy Laura, are schools on vacation? Are schools on vacation?
Unless you're year-round school in year-round class, so then yes.
Okay.
That's the only one I know. But the answer's no.
You know, I used to hate missing any school. One day it was snowing and I was begging to go to school and my mom's like, there's no school today. You can't go. Yes, I mean, it's. Mhm. All right, everyone, it's 8:50. It is now 9 o'clock. I'm going to call the docket. When I call the docket, if you're here, you need to stand if you can and let me know that you are present. Otherwise, a warrant may be issued for your arrest. Roxanne Hutchinson. Roxanne Hutchinson. Xavier Martinez, custody. Marcus Trammell.
Present.
Thank you. Jamar Clark. Jamar Clark. Joseph Smith. Thank you. Eduardo Reyes, custody. Tiffany Martinez. Omero Sanchez. Or do I pronounce the H?
No, you said it right.
All right. Omero Sanchez.
Custody honor.
Thank you. Janet Silva. Eduardo Reyes. Enoch Segundo, custody. Joseph Mejia. Joseph Mejia. Haley Moy, custody. David Estrada Nava. Virginia Vela Torres, custody. Robert Castillo. Jacqueline Vera. Haley Moy, custody. Samantha Malik. Juan Uribe. Herbert Morales, custody. Jeremiah Miller. Daniel Guerrero. Domingo Rodriguez, custody. Brennan Cornish. Yes. Adrian Harper. Adrian Yolani Jakaris Harper. Justin Zavala. Justin Zavala. Taj Davis, custody. James Austin. Thank you. Stephen Riley, custody. Wilfredo Salinas. Salim Hargett. Gaspar Rodriguez, Anthony Warrington, custody. Lindsay Hernandez. Lindsay Hernandez. All right, is there anyone who came in late or your name was not called? Yes, what's your name? I'm sorry, what? What did you say? All right, do you have a case number or SID number? 919?
909-305.
All right, do you have an attorney?
Yes.
Do you know who your attorney is?
Forgot his name, Judge.
All right, just have a seat. We'll get with you. Is there anyone else? Yes. I'm sorry, what?
Linda Corley. Your name again?
How do you spell your last name? All right. And do you know your case number or SID number? Everybody's whispering today, or can I just not hear?
I don't think it's about very loud.
All right. I don't know, just have a seat. We'll get with you. You're welcome. Anyone else? All right, everyone, please confer. I'm sorry, oh. Okay.
Recall.
Robert, let me just tell you what happened to me. That was so shocking.
You ended up on Inside Edition
No, I did.
and Court Camp? I saw that.
Yeah. No, this is what happened. So Bashan wanted me to sign some documents. I didn't have a pen. She gives me a pen. And then I notice I have betrayed. Yeah, I betrayed my team. I betrayed the Cowboys by signing with her Pittsburgh Steelers pen.
Well, and it's Cowboys week, so I mean, of all weeks, right? I mean, this is the week to do it.
Oh, yeah, we will see what
It's
happens.
not playing on Sunday, right?
I know, or Lawrence, or the Cowboys are like,
Yeah.
they're an infirmary, so.
Matters if they played anywhere, Judge.
I don't think it's a great matchup for them.
Robert.
Andrew. It's like a recall. It's like it's fine.
So I don't know, the trial that we went earlier last month. So we're supposed to handle the final sentencing hearing. Oh, from Salinas.
You just got here? What's your name?
Francisco.
Yes, we're working on that.
First row. Sit in the first row.
Since you brought in Jen.
Okay, yeah, Angelini's, I think Angelini said that he would do the sentencing since he did the trial. So, all right.
I had was on Monday, if I didn't have this one. I got the notice and everything, but it's not on the docket. watching it and I was like, oh my God, like, it was just, I watch it all the time.
Yeah. But you know what the funny thing about it is? Because Deputy Laura asked me if I remembered the case. I'm like, oh yeah, I remember the case. She came in and she was interfering with security and they had told her, you know, you can't do this. And so she came in shorts, which at the
Yeah.
big scheme of things is sort of like I've had people come before me inappropriately dressed. But then she started interfering with the inmates, taking photos of them and talking to inmates. And I'm just, you're not allowed to do
Yeah,
that.
yeah.
And so Deputy Laura and everybody, and I even told her, I'm like, come forward. First, you're dressed inappropriately in shorts. We're not here for a picnic. And then I'm like, secondly, you're talking to inmates and taking photos of inmates. I'm like, that is not allowed. In what world would that be allowed? And so I told them to take her into custody. So she sat in the box for like 2 minutes. And then
Right.
I had a conversation with her. I said, you cannot be doing this because otherwise, you know, I could send you to jail for disrupting
Sure.
court proceedings.
Yeah.
I said, but do not do that. And I said, the photographs you took of the inmates in the box, which you're not supposed to do, you need to delete those photos. So she showed her phone to the deputies and she deleted the photos of all the inmates she was taking, which made no sense to me that she was doing that. And then that was the end of it.
Yeah, that's not even like, there's like way, way crazier things that happen like on a daily basis than that, yeah. Yeah. Okay. Yeah, it's weird because I actually, like, I got the notice on it, but I don't see it on the docket, so it's kind of weird. Usually if you get the notice, right? It's good.
You're talking about.
No, no. Oh, well, yeah. Well, I didn't even get, so this was sent on Monday. I got no notice on it. Like I looked, I got,
When you get notice and it's not.
right. Oh, yeah. Yeah, I was like, what is that? And I was like, I had nothing in my, sometimes it's on me, like, you know, I mess things up.
Always takes at least 10 minutes. Yeah.
Yeah, it's like a busy morning, so.
I might get Tyler on it.
Isn't it? I know on our end, public search is weird too.
All right, everyone. So the case that you all did a jury trial on with Judge Angelini, what is that person's name? All right. So I'm trying to get in touch with Judge Angelini to do the sentencing. I think a PSI was completed, was it not?
Yeah, PSI and the tap.
All right. So if there's no objection, I can go forward with the sentencing if you all going to waive that, or either Judge Angelini can come over and do it. Okay, all right. All right, so we'll wait. Judge Angelini is on the phone now. Roxanne Hutchinson. Jamar Clark. Joseph Mejia. Adrian Harper. Justin Zavala. Lindsay Hernandez. All right, everyone, yes. Okay, can you ask him Um. It's Thursday. It's Friday Eve. We can play it by ear.
If someone, if there's someone available to go down, but if not, I'll have to go to.
Okay.
Since we know for sure. it's going
All right. All right. Thank you. LaShawn, I think we can proceed under rule 3.106.
Point, sorry.
106. And do expedited instructions. And then the receiving state has 2 days to respond, saying that they agree with us that it should be expedited in its emergency. So I think we can do it that way. And on that case, was a PSI completed?
Judge, that's the case when it's on probation. I mean, and then they put him up for appeal, so that process took like 3 years.
Okay, so did he go to jury trial?
Yes.
All right,
That up
so
north?
he was found guilty and he ended up getting probation? Okay,
Yes. And he appealed it.
Yes.
okay,
You guys are talking about Norris, correct?
yes.
Yes. He lives in Tennessee.
What was the, what's the offense?
DWI.
There's exception
No.
with that offense. I've never had anyone turn away with that offense.
I say we just do it under the 3.106 and ask that it be expedited, and that's 2 days. So he can be there under that rule. Bridget, if you want to review that, this is my only copy though. So if you want to make a copy,
Judge Mathers,
yes.
this is the motion to withdraw from when we talked the other day. I had my client here this morning.
Okay, all right, just give me one moment, okay?
My other child?
So,
Are we gonna set it for compliance or you're just gonna make a recommendation?
I'm gonna make a recommendation because of the nature of the offense.
Okay.
But, I'll do it and then you can speak to Ms. Ferguson about putting it on the docket, but for now, because he's on scram. Yeah, this is an issue.
Okay.
Okay. Norma, on this case, Mr. Mateus. Bridget is probably gonna be asking for a hearing on that, but I want that to be placed in the system already.
Okay.
All right, Patsy Hunt. Patsy Hunt. Come forward. All right, if I could have a prosecutor, please. This is a motion to withdraw. Court is calling night mag number 7257789, State of Texas versus Patsy Jackal Hunt. Can I have parties announced for the record for the state? Defense.
Linda Corley.
And are you Miss Hunt?
Yes, it's Jack.
All right. Your attorney has filed a motion to withdraw. Do you have any objections?
We're both in agreement. This is for the best interest.
All right, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record. All right. So I'd asked you when you were not under oath, but I'm asking you now. Your attorney has filed a motion to withdraw. Are you aware of the motion to withdraw?
Yes.
All right. Do you have any objections to her withdrawing? All right, then the motion to withdraw will be granted. Counsel, you are excused.
Thank you, Judge.
You're
I have
welcome.
another case in here, so I'll be here.
Okay, all right.
Ms. Hunt, be excused.
Just one moment. Let me give her some instructions. So, Ms. Hunt, you say that, and state your excuse. You say that we're off the record. You say that you're going to hire an attorney? All right. So just make sure you have that attorney hired before your next court date.
Yes.
And if for some reason you're unable to afford one, then we'll have to do a process where you evaluate it to see if you can actually afford one. All right, then.
I just
you-
need to find one that's gonna take the case and
Okay.
we had to do this. So
All right. Well, you're excused.
awesome.
Thank you. Roxanne Hutchinson. Jamar Clark. Joseph Mejia. Adrian Harper. Justin Zavala. All right, thank you. For those of you who your attorney is not here, I would suggest you step outside and call them because we're recessing at 12. And if your attorney has not shown up by then, you're gonna have to come back this afternoon or Friday.
First row. Have a seat on the first row.
Yes.
Where is she? Roxanne Hutchinson.
Mr. Lita?
He's present.
Oh, he's with you?
Yes.
Oh, okay.
Peter?
No, no. He just didn't know what was going on.
It's just a review.
Oh, okay. Was he on the docket today?
You added him.
Did I? Six to document. Okay. Give me 1 second.
She's number 17.
Oh, okay.
Oh, no. I'm not looking about their age. No, no, no.
Do you have a date on the clock?
It's unindicted. It's 95749-226. June, that's your. First row, ma'am. Hutchinson, first row. Four.
Roxanne Hutchinson. All right, thank you for dressing appropriately for court. But why were you late for court?
I wasn't, I thought it started at 9 o'clock. I was here a little bit. I have been sitting here, but I didn't know you called docket already, so we were just sitting in there.
Docket is at 9 o'clock
Yes, ma'am.
and it's inside the courtroom, you understand?
Yes, ma'am.
All right. So where are we on this case?
So I'm still conferring with my client. I can get a reset.
All right, how old are you?
41.
And counsel, you received all of the discovery?
Yes.
All right, your plea deadline date is going to be October 31st. On that date, you need to let the court know whether or not you've reached an agreement. If you have not reached an agreement, then your case will be set for jury trial. Do you understand?
Yes, ma'am, I do.
All right, Ms. Ferguson, if you give them a reset date for October 31st for a plea deadline date. All right, is there anything else? All right, thank you.
Thank you.
Judge, I think I'm gonna be out of town today.
All right, October 29th.
Hi, Judge.
Hello, how are you doing?
Quickly, if I could, a young lady is hiring me this morning.
Okay,
I am right in the middle of a hearing down in the 2:27. Now run back up in about 30 minutes. I'll be there
Sure.
as fast as I can.
Yes, no problem. Don't run.
Okay, thank
You
you.
know, all right, thank you. Okay. I think he was just hired 2 seconds ago.
I understand. I just-
Oh, no. Okay.
Y'all kind of do step by step on your settings. You need to tell me which step I'm on with Mr. Trammell. It's relatively new. I know he just got indicted because I filed the examining trial to get him indicted. They drug their feet forever, ever. So he just got indicted. Sorry? Yeah, he just got indicted August the 8th, so. What's the first step? Discovery?
Yes,
Thank you, Judge.
you're welcome.
Oh, yeah. Jeremiah Miller. Miller. Thank you.
You're welcome. Jeremiah Miller. Good morning. Thank you for dressing appropriately for court. All right, so where are we on discovery?
Judge, I just conferred and, I'm looking through discovery. There were a couple of things they're gonna check and see if they've uploaded yet for me. But I have enough to confer with them and I'll be talking with my client. So we just need to do a reset at this time. I believe this is our first setting.
All right, so what discovery may or may not have been uploaded? Okay. And state, do you have the judgments? And did you tender an offer today or no? All right, how old are you, sir?
44 now.
All right, I'm gonna put your plea deadline date for October 31st. At that time, if you don't reach an agreement with the state, then your next setting will be a jury trial setting. All right, thank you. So we'll be back on October 31st. Norma, if you can give them a reset for October 31st. All right, is there anything else, counsel?
Judge, if I just may check my calendar real quick, I just want to make sure. What is the 31st? What's the day of the week?
It's Thursday.
Thursday? Can we, Judge, can we do the 30th instead?
I'll do the 28th or 29th.
The 28th, Your Honor.
All right, Norma, put it for the 28th.
Thank you, Judge.
You're welcome.
May we be excused?
Yes, after he signs the reset form. Hello, good morning.
Ms. Samantha Lopez, I'm gonna Zoom at 10 o'clock. I just.
Yes.
wanted to-
Yes. All right, they haven't zoomed in yet. As soon as they zoom in, I'll let you know.
Thank you, Judge.
You're welcome. Oh, let's just see what ends up happening with the case first, and then let her attorney know. All right, who's here on Umberto Lara? All right, and where is your client?
Present in the back of the courtroom, would you like him to approach?
Yes.
Morning, Judge.
Good morning. Just one moment. Thank you for dressing appropriately for court. So we're here on a motion to modify bond conditions. State, are you ready to proceed on the motion?
Yeah.
All right, court is calling NIMAC number 749226, State of Texas versus Umberto Lira. Can I have parties announced for the record for the state? Defense,
Kim Gonzalez for defense.
and are you Mr. Lira? All right, defense has filed a motion to modify defendant's condition of bond. And are you requesting tracking only?
We were requesting tracking only, Judge. He has not been allowed to work. The state is in agreement to allowing partial from 7 a.m. to 8 p.m.
Mhm.
We were requesting tracking only, but if the judge, I'm sorry, if the court sees that, at this particular point in time, tracking from those hours is appropriate, then we're fine with that. We just need to give him an opportunity to get back to work and earning some money.
State?
That, we are opposed to the modification to rate track only. We are in agreement to give them a little bit more time. More of this student as a mobile mechanic. I have many questions on the complaint, but I just want to have others.
All right. So of course, I know what a mobile mechanic is, but if you want to call your client as a witness to explain why the hours that the state maybe is not, is only given him is not sufficient. Otherwise, it will be work for a specific time frame.
Judge, I'll call him briefly.
All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up because the court reporter has to hear and I have to hear. If you'll state your name for the record.
Umberto Lira.
I'm sorry, what?
Back to the
Thank you. You may proceed.
Mr. Little, will you please tell the court how you're employed?
mobile mechanic
And can you tell the court a little bit about how you get your jobs?
by recommendations of people that have done jobs for them.
Okay. And so when people call you, are you available? Do you try to make yourself available to them all hours of the day, or do you have a set time schedule?
No, whenever they call, and sometimes they come in at night. Just to check out the car, check out the stuff.
Okay. And so are you just at the mercy of whenever people call you for work?
Yeah.
Now, you're asking to be available after 8 PM or to be placed on tracking only should you have people call for business, but if the judge is able to allow you to work from 7 to 8, is that still helpful for you to get business and be able to pay your bills? And also you have a daughter in school that you have full custody of?
Yes.
Okay, and so you've been paying somebody to take her to school in the morning? Okay, so if you're allowed to travel from, before 7 AM, let's say, you'll be able to take her to school yourself? That's all I have, Judge.
Any questions? All right, so I have a few questions, if there are no objections.
No.
All right. So with regards to your business, when someone calls you and you go out, how are you paid?
Cash.
So here's the issue the court is having. I would be fine with him tracking for his work outside of hours, but there needs to be some sort of documentation that he's actually at work. I know usually sometimes people will sell, understand sometimes people pay cash, but then there's no verification that he's at work. So that's my issue.
I'm sure we could put together some sort of receipt, Judge, for hours billed or something like that, if the court's requesting documentation while he's performing hours if he's out.
All right, and state, with regards to him being on tracking only for employment, what is your concern?
Concern is that he deviates from his working hours for his business to go elsewhere, or that may stumble upon as he's out and started new offense or violating no confidence. And it's also taking into account safety. Yes, I think it what there was.
All right, so the court would not be able to see documentation that verifies that you are actually working at a specific location, just doing a cash business, which I understand sometimes when businesses are brand new, they do cash, but there's no verification. If there were some other link or square or something of that nature, then the court will be better able to say, oh, he was at his place of employment, with person A, B, and C. But with cash, that's not possible.
I could give a receipt.
No. So what I'm going to do is I do believe, I understand people, their cars don't break down between just 7 AM to 8 PM. But this is where we are until you change how you receive payment. Then this is what the court is going to order. So what I'm going to do is I'm going to modify conditions to include partial GPS. And what I will do is 7 AM to 8 PM, that can be a curfew. Do you have any objections to that just being his curfew so that he can take his child to school or?
No, not about this. I think that was the purpose of bringing it to 7 AM to allow.
Okay. And is this just Monday through Friday or Monday through Sunday? Well, all right, so your curfew Monday through Friday is 7 AM to 8 PM. And what about what is happening on weekends?
I mean, obviously, Judge, we would respectfully request that he be allowed to work on the weekends as well. I understand your concerns. Maybe if we give him an hour range of what the court deems appropriate during the day.
I think we should probably wait and see if this is successful, and in the event there are clients that actually need the services on the weekends. Maybe we can use that and see if we can on time.
So state, you're stating that you do not want him to be out of the home on Saturdays and Sundays?
It's not a conditional. If he's on PPS for partial arrest, the only reason why the niggas are out to leave is. So yes, you would get.
All right. Well, with the partial GPS Monday through Friday, my understanding of your request is that he's just to have a curfew, which is 7 a.m. to 8 p.m. Am I wrong? All right. Wrong, correct, or correct, correct? Okay. So then this is what the court is going to order. There's going to be partial GPS. You will have a curfew. So for Mondays through Fridays, you can be outside the home from 7 a.m. to 8 p.m. And that 7 a.m. to 8 p.m., you can go to the store, take your daughter wherever she needs to go. So it's just not for work. That is just your curfew. And if you work between those hours, great. But it's from 7 a.m. to 8 p.m. Do you understand? All right. And then I'm assuming there's already a no contact order with the complainant. And if anyone has an address or anything they wish to add to the order or some location he's not allowed to be, then you all can add that to the order. So I'll hand the order to you all so you can put the information in about the complainant's name and any locations he's not allowed to appear at. All right, is there anything else?
No, Judge.
All right,
Thank you.
with that, you will be excused, and your next court date will be whenever you're indicted or if your attorney decides to have a request for you to come to court. All right, thank you. And counsel, you may want to make sure that you contact pretrial services because sometimes with regards to the GPS, sometimes there's some issues when you just do a curfew. So I don't know who his pretrial services officer is, but you may want to contact them.
Okay, Judge. I'll do
You're
that.
welcome.
Thank you.
You're welcome.
Hold on, Judge. But I'm just, I don't know. I can get her.
Marcus Trammell,
Morning, Judge.
good morning. Hello. I saw him outside before I came in. I was telling him his shoes are fabulous.
Yeah, I told him the same.
All right. So first things first, before we get to your motion. Where are we on discovery?
To my knowledge, we have all the discovery that the state has.
All right, and then we have a motion, let me see. All right, we have a motion for removal of GPS. State, are you going to object to that?
Yes.
All right, we'll go on the record. Court is calling 2024 CR 008165 State versus Marcus Trammell. Can I have parties announced for the record for the state?
Jason, here, I have one.
Defense?
Charles Bunk for Mr. Trammell, excuse me.
See, I was right.
You-
Are you Mr. Trammell?
Yes, ma'am.
All right, we're here. The defense has filed a motion to remove the GPS. State, is the court's understanding you're objecting to removal?
That's correct.
All right, and why is that?
Judge, I just became aware of that actually just right now.
Okay.
But we are opposed to considering the charges that presented in this case of terrorist and threat. And the safety of the community, I believe that GPS is appropriate in this case with the facts that are surrounding the case.
All right, defense?
For the purpose of the hearing, may I call my client?
Yes. If you can raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Marcus Schmel.
All right, defense?
And Mr. Trammell, how long have you had the monitor on
Since after the Super Bowl.
of this year? So
Yes,
basically February of,
February of 2024.
so that's about 7 months,
Yes,
correct?
sir.
And you had an attorney before I became your attorney, is that correct?
Yes, sir.
And then when I became your attorney, it was probably about 2.5 months ago. You still, at that point, even though your case was from January, you still had not been indicted, is that correct?
Correct.
And then you were recently indicted August the 8th as a result of our filing a motion for an examining trial. Do you remember that?
Yes, sir.
Now, that you've heard the state say that their concern is for the safety of the community, et cetera. While you've been on the monitor, my review of your records are you've had no violations of the monitor. Am I correct in my review?
I believe so, sir.
Okay. And you understand that if the judge was to remove the monitor, one of the conditions she can set, of course, is you have no contact or you go nowhere within 1,000 feet of the employer that is that's charged you with this offense or that property. Is that you understand that?
Yes, sir.
You understand that if you were to be found to have violated that, she can revoke your bond and place you in custody until we have our trial.
Sir.
Are you still asking that the judge considers this motion?
Yes.
Can you describe briefly for the judge some of the hardships caused to you by the monitor?
I'm a disabled veteran, 20 years retired. I'm used to being able to have my freedom, be able to enjoy just getting out and about, dressing up. I do not feel like a human. I don't feel like I am being seen. I don't think I'm being heard. All I did was report ethical violations against me. I'm talking about the effect of the monitor. It has mentally destroyed me. I have
So
given
let me ask
20
you this.
years to this
Here's-
country.
Well, just 1 second. Here's my question. What type of GPS is he on?
I'm not aware, Judge. Sorry.
Is it full
What were the
GPS?
conditions?
I don't know. I've never been told what my restrictions were.
All right, so this is what the court needs to understand. And if somebody, I'm gonna have you guys step back.
Yes, Judge.
If somebody can tell the court, is he on full GP? Okay, so here's the thing, Mr. Trammell. Before I make rulings, I love having information. But I will tell you, if you are being upset, not letting your attorneys ask questions and interrupting, that's not a good look for what you're charged with, okay?
Yes, ma'am.
So I need more information. I don't know if he's on full GPS, partial GPS. I don't know any of that. So if y'all will discover that and bring
I
it
will
back
get-
to me,
Yes,
and then we will continue with the hearing,
yes, Judge.
okay?
Yes, Judge.
All right, thank you. Raymond,
Yes, ma'am.
on Umberto Lira, what you, both of you in the state wrote down, what was the partial GPS on, I'm sorry, you in the defense wrote down. I still think of you as being on the state. What was you guys wrote partial GPS to remain the same on weekends?
Well, technically, he's not allowed to go anywhere on weekends because of the GPS, right? So I would imagine that would stay the same.
Okay. All right, because let me just tell you, if you do that, there's gonna be a misunderstanding.
With pre-trial?
Yes,
Okay, if.
so,
You can write over it, that you like make changes, that's fine.
okay,
As long as we're all understanding
All right.
what we're trying to do.
all right, thank you.
Right here. tracking only on that one. Yeah, CPS modified the tracking only back on March. This is, yeah. this is
All right,
February,
thank you.
so it's not tracking all of it. Okay.
And I don't know, do y'all want to put the complainant's address in the motion?
So I was thinking about that, Judge, but I didn't want to disclose it. I said, also as public record. I mean, I can put it in there.
No, I mean, because then they won't know.
Okay.
Like pretrial services won't know.
Right. Frequently, I will.
Okay. Or either I can just put down residence and place of employment. And I'm assuming your client knows the residence and place of employment.
I don't know if he still does at this point in time, Judge.
Okay.
It's been a while.
Counsel, yes.
Have they gone in, Judge?
No, they
Let
haven't.
me, can I go outside the call?
Sure.
Thank you, Judge. I don't want to be outside when they walk in.
You're welcome. All right, so whenever you all are ready with Mr. Bunk's client, just let the court know. Okay. Domingo Rodriguez.
President, Your Honor. Service.
Okay. Oh, if he wants to come up now, I'll take this up and then we'll do that. All right, where are we on this case?
Yes, Your Honor. Having since just been indicted recently, it's the very first court setting where I've been able to confer with the state here in the courtroom. I looked over the discovery, Judge. It does seem light. There's 3 separate officers from Leon Valley Police Department, so I requested that the state look into that as well as a potential issue with the legality of the search, Judge.
All right, Ms. Ferguson, set this for discovery on November 4th. All right, is there anything else?
Nothing further, Your Honor.
Do you have any questions, sir?
No.
All right, we'll bring you back on November 4th.
Thank you, Your
Is it a possibility your client will be released from custody?
Honor. I don't believe so, Judge.
All right, Ms. Ferguson, if you could give him a reset just in case.
Yes, Your Honor. We'll execute.
Thank you. And counsel, on your client, your other client,
Yes, Judge.
the bondsman is getting off the bond.
Yes, Judge, became aware of that. I did file a motion for defendant's personal recognizance bond, the mental health bond. She does have issues. And she also does have an appointment with mental health courts next week on the 8th of October, Judge. And I have that referral here. I don't know if you wanted to take up the matter now or maybe a little bit later.
Just give me one moment because a judge is coming up to do a sentencing.
Yes, of course, Judge. I'll be
Sure.
around.
Thank you.
Yes.
Will do.
Mr. Buck, you're back.
All right, just give us a moment because Judge Angelini is coming up very quickly to do a sentencing
Oh,
for a jury trial that he heard.
Okay.
It shouldn't be that long.
okay.
And could I have the file on the case that Judge Angelini is hearing, please? Oh, so the interpreter is not here yet? All right.
If I would be excused.
Yes. Charles, I'll take your case. They're waiting for an interpreter. All right, Mr. Trammell? Sure. We're back on the record in 2024 CR 008165 State versus Marcus Trammell. All right, so the court has received a report that he is currently on tracking only, and that was modified to tracking only on March 18th, 2024.
That is correct.
All right, so what are the issues
Well,
with tracking?
What I,
only?
well, the issue was, he had made me aware of some physical issues, some medical issues, if you will, and that's what
I'm sorry, just
of
one
course,
moment.
of course.
All right, yes.
So he has voiced to me, he's had some medical issues that has caused him multiple times to have to switch it from one leg to another because and that's what I was trying to address with him, the troubles he's had with it. That's his biggest issue is his health.
Mhm.
It's, without going into graphic health details in a public forum, he's had some medical issues
Right, so do you
related to
have documentation of the medical issues?
other than my client's statement, no, Judge.
All right, has anything been given to the state? Are you aware of medical issues with regards to the GPS? All right, so, Mr. Trammell, I just deal in fact, right? So if you have medical documentation about the GPS, present it to the court, and I will strongly consider removal of the GPS. But I need those documentations.
Yes, Judge. Okay.
So, and your attorney can bring you back on any date. If your attorney wants to come back on Monday, they can come back on Monday with the medical documentation. And I'll strongly consider removal of the GPS. All right, and then state at that.
Circle back to his setting, before we're excused, can we circle back to his
Yes,
setting? Okay, thank
yes,
you.
we will.
Thank you.
So then in state, I don't know any facts of this case or what's being alleged. So that would help me with regards to whether or not removal is appropriate. Okay,
Yes, Judge.
all right, so setting. When would you like this to come back for a hearing on the GPS matter?
Judge, I don't have an exact date. We'll have to see how quickly we can get the records. So,
All right, so this is what I'll do. I'll set you for a final discovery date in 30 days.
yes, Judge.
And then if you have the records before then, you can always come back in.
Yes, ma'am.
All right, so Ms. Ferguson, if you'll put this for November 12th.
Judge,
Are you?
I come back on the 13th.
All
So
right.
can we just move it a couple of days after
Yes,
that?
put it on November 14th. All right, is there anything else?
Nothing else from the defense, Judge.
All right, thank you.
Thank you, Judge.
Oh, thank you, you're excused. Thank you. And thank you for dressing appropriately for court. You always do, though. Morning.
She's here today.
All right, could I see the file on Samantha, you say Lopez?
Yes, Your Honor.
Could I see Samantha Lopez, please?
Yeah, they said it.
And Maverick County, if you could unmute, please, and start video.
We're ready.
Hello, thank you so much, Maverick County.
Thank you.
All right, can I see the file on Samantha Lopez?
Yes, that's me, Your Honor.
All right, just one moment, I'm grabbing your file, okay?
No, ma'am. It's, case number is, 2022 CR 4501. She's, remanded without bond. I don't know if that would be in the back.
Give me the case number again.
Judge number 2022
Mhm.
CR 4501, Your Honor.
And are you seeking to have a bond?
Yes, Your Honor. She's remanded without bond.
Okay,
She obtained a while back.
all right, State, could I see someone on this case? It's a family violence case.
Okay. Do we do some bond? No, it's just set a bond because she remanded without bond. I believe last time it was 10,000, Judge.
All right, we're going to go on the record. Could everyone please whisper? Court is calling 2022 CR 4501, State of Texas versus Samantha Lee Lopez. Can I have parties announced for the record for the state? Defense,
Amir Memorial, Your Honor.
and are you Samantha Lopez? Miss, in Maverick County,
Yes,
are
I
you
am.
Samantha Lopez? All right, the defendant is appearing by Zoom. Any objections from the
Yes,
state?
Your Honor.
No objection.
Any objections from the defense?
No, Your Honor.
Ah, she's frozen. Okay. All right, so we are here, counsel, you're requesting, do you all have the phone? Thank you. Counsel, you're requesting a bond be set?
Yes, Your Honor.
All right, so why was she remanded without bond?
Judge, I believe I was retained on this case earlier this week. My understanding is she failed to appear for her prior hearings, Judge. I don't know if it was a trial setting or a sentencing, but she failed to appear.
All right. You want to call your client to find out why she wasn't present in court?
Sure, Judge.
All right, Ms. Lopez, can you raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
You can lower your hand, state your name for the record, please. Thank you.
Samantha Lee Lopez.
All right, defense.
Ms. Lopez, my name is Amir Memorial. We haven't met, but I was retained by your family to represent you. We're here today to set bond because we managed that bond. You were set, Judge, when was she set here last time?
June 6th.
June 6th of 2024. Can you tell the court why you failed to appear, ma'am?
Oh, I'm sorry,
Um,
let me correct that. It was June 6, 2022.
2022, yes.
Yes.
Can you tell the court why you failed to appear on that date, ma'am?
I was not aware that I had a court date because I was not following along with anything that I needed to take care of.
Okay, I don't understand that last statement. You said because you were not following through with what?
With any of the things that I was supposed to. I wasn't talking with my lawyer. I wasn't checking in with the courtroom. I wasn't doing any of that.
I think Judge, she takes responsibility for that. So I think
Yes.
last time the bond was set at 10,000.
Oh, just one second.
Sure.
State, do you have any questions?
Yeah, so why are you at the Maverick County Jail?
Why are you at Maverick County Jail?
I went to into Mexico for a dentist appointment, and when I was crossing the border back, they ran my name at the border, and I came up with 2 warrants.
What are the warrants for?
One is for DWI and one is for assault.
If I may, Judge, County Court 6 has set her bond at $5,000. That's a DWI case.
All right. Any other questions?
No questions.
All right. All right, do you have a place to stay? If you're released, do you have a place that you can live?
What was that?
When you,
Oh,
if
yes,
you
ma'am.
are
I have my own
released-
home.
All right, you have your own home?
Yes, ma'am.
Who is in the home with you? Any minors?
No, ma'am, it's just me.
Do you have any children?
No, ma'am.
Any drug or prior drug use?
No, ma'am.
Any prior mental health issues? Any prior mental
I
health
have
issues?
when I was younger, ma'am, but not recently, not in a lot of years.
All right, and what was your prior mental health issue?
I was suicidal and I had anger issues.
All right, are you currently under any type of a doctor's care for
No,
mental
ma'am.
health issues?
No,
Since you've been in custody in Maverick County, have you experienced any mental health issues or have you been given any type of mental health medications?
no, ma'am, I have not had any issues.
All right, anything else from either side?
Yeah. No objection. I really see the bond of $10,000. Judge, as long as the conditions stay the same, I think there's no contact order with complainant along with strong firearms.
Absolutely, Judge. Judge, on the 10,000, I'm not sure. I think that was what the amount is, but I'll leave that to the court's discretion to confirm that, please. I want to make sure that that was my understanding, but I may be wrong.
All right, Ms. Lopez, are you able to afford a $10,000 bond?
Yes, ma'am.
All right, the previous bond was actually 20,000.
20,000. That, okay, Judge. I'm sorry.
All right, that's fine. I mean, both parties have agreed to 10,000. So the court will set your bond at $10,000. There's be no contact with the complainant or the complainant's residence or place of employment.
Okay, yes, ma'am, that's fine with me. I haven't spoken to her in a few months.
All right, and then this is going to be set for hearing in this court. Defense, have you received all of the discovery?
Judge, I have, yes.
State, were you able to tender an offer or no? All right, so this is going to be set for October 28th. Is that a good date for you?
Yes, Your Honor.
All right, it's going to be set for October 28th for a plea deadline date. Of course, if your client is still in custody, the court will reconsider.
Thank you. Thank you.
All right, is there anything else?
Judge, we greatly appreciate the court's time and effort.
In Maverick County.
Yes, and getting this together in Maverick County also, Judge.
All right, thank
Thank
you. So your next court date is October 28th. You need to make sure that you're here in court. It's at 9 a.m. You understand?
Yes, ma'am, I will be there.
All right, thank you. Have a good day.
Thank you.
All right, thank you, Maverick County.
Thank you, ma'am.
Thank you.
All right, you're excused.
Thank you, Judge.
You're welcome.
Oh, do you want to take that to the back or the clerk?
Oh, I'm gonna hand it to them.
Okay.
And if you want a copy of it, that's remaining, they'll give you a copy.
I would, Judge, please.
Sure. There you are.
Mayor, do you want to take a photo of it? You're short-handed right now.
Can I make a copy in the back?
Somebody in the back.
Okay, let me go to another court. I'll be back. Make a real quick copy. I'll be back.
Thank you, Nat. Thank you, Judge.
You're welcome. Have a good one. All right, Juan Uribe. All right, hello,
Hi, Judge.
Mr. Uribe. Hello. All right, so today is plea deadline date.
Yes, ma'am, and we will be turning in our pretrial diversion application this morning.
Okay. All right, so you're gonna be reset for November 4th. Is there anything else?
No, Judge.
All right, thank you for dressing appropriately for court. Just remain in the courtroom and the coordinator will give you a reset date for November 4th.
Thanks, Judge.
This is your evening plea debt, PTD. Okay, thank you. You're welcome. Joseph Jefferson Smith. Hello,
Judge,
morning, how's it going?
it's going good.
All right, so let me just put him in the system. All right, so on this case, where are we on discovery?
I just did the discovery acknowledgement this morning. We have everything.
State, were you able to tender an offer?
Not at this point. We haven't got anything.
Counsel didn't want.
All right, do you have an offer to tender today? All right, when will you be prepared to tender an offer?
And tender an offer today.
I didn't approach him on an offer, so.
Okay, so I'm gonna have you all get an offer before you leave the courtroom. And this is gonna be set for, how old are you, sir?
42.
All right, so this is gonna be set for a plea deadline date. Norma, put this on November 7th for a plea deadline date. All right, your plea deadline date is going to be November 7th. All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
All right, thank you.
Thank you.
She said. We have a motion, but we also have a new case coming up.
Yeah.
Thank you.
Oh, okay.
I can have your defendant email
Got it.
address at the bottom.
James Austin. And then Norma, on his case, Scott's case, I don't have.
I put the file. You guys want it?
Okay, I just have it. All right, thanks.
Do you have a copy of the motion? Judge, do you have a copy of the motion on Mr. Austin's case?
Let me see, just give me a moment.
Okay, sorry.
To modify bond conditions.
Beg your pardon, Judge. Yes, Judge.
All right, state, have you seen the motion?
But he's aware of what it, he knows what it says.
Okay. All right, court is calling NIMAC number 7588035, State of Texas versus James Austin. Can I have parties announced for the record for the state?
Daniel Rosenberg for the state.
For the
Charles
defense?
Bunt for Mr. Austin.
Right, and are you Mr. Austin?
I'm James Austin.
Just a moment. All right, let's go off the record for a moment. So this case is an injury to a child, correct?
Correct.
All right, and the children that he wishes to see is one of those, are one of the children the alleged complainant?
Yes. And they're all present and the state's had an opportunity to talk to them today.
All right, and is CPS involved or no?
No.
No, Judge.
State, are you aware of CPS is involved?
I do not have any knowledge, yes, involved at this time.
Did anyone check? Is there some documentation that CPS ever go out to the location? The reason why I'm asking these questions, because if CPS is involved, they will have certain conditions.
Your Honor,
Yes.
if I may, yes, there is a CPS case, and the case I.
All right, so here's the thing, Mr. Austin, before you speak, because there's information that I need. I know you're saying that the CPS case, maybe it's closed or maybe there are no conditions that have been set. But what I've discovered in my previous lifetime working CPS cases, sometimes the clients think something has happened and it hasn't happened. So here's the problem with me entering any orders, and I'm not saying I'm going to grant your your attorney's motion or not, but I need to know if there are CPS orders and what those conditions are. Yes.
Yes, ma'am, with all due respect.
Okay, don't ever do with all due respect, because then what follows,
I
people say,
wasn't aware of that.
yeah,
Just trying to be
that's what
hard-
people
just-
always
just
say.
Trying to be nice about it.
No,
So,
I appreciate it.
appreciate that.
Yeah.
Well, I spoke with the CPS lady and my wife has suffered with mental health throughout the years. I believe in the sanctity of marriage, so I didn't divorce her. The children were released to my custody. She left the children for over 30 days.
Okay, so wait a minute.
But the
Let me,
children were given to
wait,
me.
let me stop you right there. All right. So I want everybody to be in a place of kindness, right? And to be in a place of kindness, you don't say you're only staying with somebody because you believe in the sanctity of marriage. And you don't put, for lack of better terms, their issues publicly before the court when it's not needed. This is what I need. What I need is somebody, if you know the caseworker's number or something that's going on, pick up the phone, call the caseworker, and guess what? The state and the defense can talk to the caseworker. They're going to ask for the name of the oldest child, and they will go in their system and they're going to look it up and they're going to see what the status of the case is.
Okay.
Either they're going to tell me, yes, we've closed the case and the children are supposed to be with you, or either they're going to say, you're not supposed to have contact.
That's why I was just trying, that's why I never get into that.
So
The
let's,
children were placed with me.
let's land the plane by having somebody call the CPS worker. And then I'll take up this matter.
All right, thank you.
Okay.
Judge. Okay.
Okay?
Will they let me know, the CPS people, if it's okay?
Oh, your attorney and the state are gonna call the caseworker.
Yes.
You're welcome. All right, Lindsay Hernandez.
Yes, Judge, present.
All right, court is calling 2024 CR 6058, State versus Lindsay Hernandez. Can I have parties announced for the record for the state,
Jason Garrett,
for the defense?
Renee Munoz.
All right, and are you Miss Hernandez? All right, the bondsman had filed an affidavit to surrender surety. The court signed it. And I believe one of the reasons they requested it because they believed that Miss Hernandez would not show up for court. She did not show up on October 1st, but she did show up on, well, appear on October 2nd. And then, of course, she appeared today. She was a little late, but the court is understanding of that because yesterday we talked about her tardiness and where she was coming from.
Yes, Your Honor. I appreciate that.
All right, so defense is requesting a PR bond. Off the record, we had a discussion with regards to your client's mental health issues. State, do you have any objection to the granting of a PR bond?
No, it's just a question that additional conditions be imposed.
I'm sorry?
Additional conditions be imposed of any type of substance abuse or mental issues to be addressed with that PR bond.
All right, so the court will set your PR bond at $1,000, waive fees, and there's going to be a referral to Center for Healthcare Services. And counsel, your client was here yesterday,
Yes, Your Honor.
and there were what appeared to the court to be substance abuse issues as well.
Yes, Your Honor.
So what I'm going to order is I'm going to order regular UAs, waive fees, and I'm going to order outpatient treatment
Yes, Your Honor.
for substance abuse. And I'm going to waive fees. And Miss Hernandez, do you have a place to live?
I don't know.
All right, so what housing would be available for her? I know Lifetime has just started a women's unit, but I don't think it's officially up and running, but I received an email for them saying that they were expanding.
Okay.
Probation, do you know any housing that will be able to address her substance abuse issues? I know there's Alpha House. but-
Yes, I was gonna.
Mental.
Just that.
side.
Yeah.
So Alpha Home?
Alcohol judge and, I have another one in mind, but it's slipped my mind the name, if you give me just a moment or two.
Okay.
I also know that Sam Ministries does good things for people that need housing in terms of homelessness. They are able to sometimes provide people the avenue for apartments, things of that nature, transitional living to get them set up on their feet. And also Haven for Hope Joe Outreach Judge, I don't mind getting in contact with them just to explore these avenues. But the biggest thing, Judge, is I know that she has that appointment here with Mental Health Court, that they can put her into contact, make sure she gets in contact with Center for Healthcare Services. And then they have caseworkers there within Mental Health Court, Judge, that have good access to resources too. So I'm strongly encouraging her to make that. I don't know if it could be made as a condition for bond too, that she shall make that appointment next week.
I'll put in a referral to mental health court.
And I have that application, Judge. Speaking of that, if the court could sign, I have that from the
Yes.
caseworker.
And then if you'll speak with Miss Abrams,
Yes, Judge.
and she'll give the location and the name of the facility that can help her with housing. So I'm going to do a referral for housing, and I'll just put referral for housing
Yes, sir.
and a referral to mental health court.
Great. Thank you, Your Honor, so much. Appreciate that.
And if you'll give that to the coordinator.
Yes,
And
sir.
then what I'm going to do is I'm going to reset this. I'm going to give it an earlier reset date than I normally would, because I think I need to stay updated with her.
Sure, of course, Your
So
Honor.
we're going to come back, oh, and state your excuse. We're going to come back on October, Norma, can you put this October 21st? All right, we'll be back on October 21st.
Thank you, Your Honor, and we will definitely keep the court updated. We appreciate it.
All right, and you do look better than you did yesterday. All right,
Moving in the right direction, yes.
all right, thank you.
Yes, ma'am.
Who's here on Tiffany Martinez?
Good morning.
Good morning. How's it going?
Okay.
All right, on this case, where are we on discovery?
This is the first setting. It's been over a year since she was arrested.
Okay,
We are just trying to get discovery. We'd ask for another discovery setting so we can get that. There's supposed to be video and several other things that we need to gather before we can do anything.
all right, State, do you know if all of the discovery is uploaded or is there questions?
One of those situations where I believe if they did their job, it should be uploaded for the fact. So I'd have to say, unequivocally, yes.
Okay,
There's
right.
a second issue too.
what's the
Before we
second
go
issue?
too farther, she's been on ELM for over a year, Judge. We filed a motion to remove the ELM.
Okay, we're gonna take that up. Let me
Okay.
get this and then we'll move in order. All right, so what we're gonna do is we're gonna come back on November 7th for discovery. So if there's something that's missing or you all think that is missing, needs to be addressed. Now State, with regards to the defense's motion to removal of ELM, do you have objections?
Yes, Your Honor.
All right, we'll go on the record. Court is calling 2024 CR 00823A, State versus Tiffany Martinez. Can I have parties announced for the record for the state?
Case here, Your Honor.
Defense?
Wait for the defense.
All right, defense has filed a motion for removal of GPS. State, you have objections?
Yes, Your Honor.
And what are your objections?
Objection in this case, Your Honor, not voted particular facts or firearm was used in the alleged crime. And it was discharged, so in the state's position, that is something that is taken of the duty and also the victim of the case. Yes.
All right, and what type of GPS is she on? Is she on full GPS, partial GPS?
She is on just the monitor, Judge.
All right, so tracking only?
Yes.
All right, and
But-
so,
But listen, she's been on for over a year.
Mhm.
She has had no violations. She has no history, nothing in her background to suggest there's any problem. There's been no communication or anything with the victim on the case and no violations of that in any way. Because of the monitor, it's been hard for her to get work, hard for her to be able to get a job. And she can address that if you want to hear more about her finding a job.
yes. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Martinez.
All right, so what is your issue with the GPS?
So I was a dental assistant, and they took away my license because of the case. I can't be seen with the ankle monitor in the healthcare setting. They think it's just not a good setting to be in.
So does PANS address that issue?
My scrubs, it bulks out so big, like it just doesn't cover. We have like the Grey's Anatomy scrunch ones and that's what the company offers us to wear. So it was acceptable. Also, with the State Board of Dental Assistant, since it's on the record, I can't renew my license for that.
Since
so-
what is on your record? Is it
Well,
the,
it's this case, it's like showing pending, I guess. So with this being on there in the house arrest, I'm not able to work anywhere because of that.
well, no, I'm sorry to keep up interrupting you, but are you not allowed to work in your chosen profession because of the charge or because of the GPS?
Oh, because they let me go because of my ankle monitor. But if I wanted to renew my license with any other dental offices, because I have tried to get another job with the dental, but because of the pending, it won't allow. But my current, well, Reassess Dental, which is where I was working at, they let me go because of the ankle monitor. They said I can go back if it was removed. So I haven't really been able to find any work. Bond is paid. I was getting like little jobs, but I was working at a daiquiri place and then the company just like sold out or they just went out of business. So it's been hard since then. Dental office did say I can go back if the ankle monitor is removed and I can finish with my position there as a dental assistant.
Okay. All right, so here's my next question. Is there any letter or anything from that facility that's saying that they will allow her to work there if she doesn't have the ankle monitor?
I can get that for you if you need. But it was my doctor that told me that. My doctor both doctors that I worked with, they did state that to me and the manager.
Okay. Any other questions?
Nothing else, Judge.
Any questions? All right, so I want to see that documentation that they're saying that they would allow her to work there if she didn't have the ankle monitor on, because this seems to be the crux of the situation before the court is she wants to work there. They're not allowing her to work because she has an ankle monitor. And then state, if the court were to grant this when we come back, I would want the complainant to be informed if the court were to remove the ELM.
I believe there's no contact with the complainant already and there hadn't been any problems.
Okay.
No violations on ELM.
Okay.
There's really nothing else in her background that
Okay.
suggests she needs this.
So as soon as I receive that documentation, or if they want to zoom in, they can zoom in today. But as soon as I receive that documentation, we can put this back on the docket for hearing at any time you have that, counsel. Anytime except for Friday, because Friday is drug court graduation and that's where I'll be.
Okay.
Can I say something?
Sure.
So it's also been a problem for any other jobs that I've tried to apply at. They see the monitor and they don't want to hire me.
Okay.
So it's not just the dental office, but it's other employments that I've tried and I have proof of like Indeed and stuff that they see my ankle monitor and they say.
All right. So again, with other employers seeing your ankle monitor pants. Right now, what you've informed me of is that you have a job as a dental assistant and that employer is saying they won't let you work with an ankle monitor. So I want that information.
So I'm not currently employed with the dental office. It's been a year. They let me go a year ago.
All right,
But
so
to
no,
go back.
yeah, so I need that documentation. So does everyone understand what the court is asking for?
Yes, sure.
Okay, all right, so we'll come back on November 7th for discovery, but counsel, you can set the other matter anytime before then. All right, thank you.
Good for me, I'm not-
Virginia Bella Torres. And is there an application in this case?
There is not, Your Honor.
Court is calling 2023 CR 0290, State of Texas versus Virginia Bella Torres. Can I have parties announced for the record for the state?
Your Honor, I apologize for over speaking, Judge. Frankie Sandoval on behalf of Ms. Vela Torres.
And are you Ms. Torres? Counsel, have you received all of the discovery?
We have, Your Honor.
And did you review that with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, Ms. Torres, did you review the document entitled Court Admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of theft from a person as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? Off the record, everyone, y'all need to whisper. Oh, and y'all can move down to that end. The deputies will move you down there. All right, we're back on the record. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Torres, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 16 months in the state jail facility. There are no applications. This is run concurrent with County Court Cause number 700040, 700039. There's to be restitution, if any, to Kimberly Inaosa and Cash America Pond for $200. And there's to be restitution payable in County Court Cause number 700040, 700039. Did you understand that to be the plea?
Yes.
Defense is at the plea?
It is, Your Honor.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No
Did you-
object.
Oh, I'm sorry, go ahead.
Again, Your Honor.
Oh,
I
no, it's not a
apologize for
problem.
speaking over you. No objections on behalf of Ms. Torres, Judge.
All right, did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports?
Yes.
But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Your Honor, given Ms. Torres' lack of criminal history, in the interest of justice, the court will consider a pre-sentence investigation given the wide range that's available to the court in deciding her punishment.
All right, if you're requesting a PSI, I will give you a PSI. The court doesn't need one. If you want to present information to me, or if you want to have witnesses come and testify on her behalf. The reason why I say that is because if we set this for a PSI, Bashan, what's the earliest we can do a PSI?
6 weeks, Judge.
So it'll be 6 weeks?
If I may have a moment with Ms. Torres?
Sure.
Your Honor, on behalf of Ms. Torres, with the court's indulgence, Ms. Torres would like to explain to you why she's accepting responsibility and would be asking for a lower range on the range of punishment.
All right, are you waiving the PSI?
Yes, Your Honor.
All right, so Ms. Torres, you're entitled to a PSI if you want a PSI. Do you understand? And so what would end up happening is at that PSI, a probation officer would come to view you, even though you're not applying for probation, they would interview you. And I would receive information about you, your criminal history, if you have any, and any other background that you give to them. And also, you will be allowed to call any witnesses that you may wish to call at that time if you have witnesses. So do you wish to, we can reset this for a PSI, which will be in 6 weeks, or either I can give you a shorter reset date if you're attorney and you are waiving PSI, and that will give you a chance to have witnesses present to testify on your behalf if you want witnesses. I'm sorry?
We can waive it.
All right, so you want to waive the PSI? Let me do this. Let me have you discuss it. We're off the record. Let me have you discuss it with your attorney. So here are your options. If you want a PSI, I will set it for PSI. It's going to be set in 6 weeks because that's the earliest they have available for somebody to interview you. If you don't want a PSI, but you want witnesses to come and speak on your behalf, which you can, then we can reset it for a shorter time, and your attorney can tell me what would be a good date for you to come back with witnesses. All right. So those are things you can consider, and I'll let you speak to your attorney and then you all can approach. James, Austin, are y'all ready for Austin?
Yes, Judge.
All right, so do y'all have information?
He spoke to CPS.
All right, we'll go back on the record. We're back on the record on night mag number 758-035, State versus James Thomas Austin. Can I have parties announced for the record?
Daniel Rugner for the state. Charles Bunk for Mr. Austin.
All right, so, and you're Mr. Austin?
Yeah, thank God.
All right, you can lower the Bible.
Look, I even covered it up.
All right, no. The reason why I say that is this. People will come before me and sometimes they bring Bibles. Sometimes the Bibles have not been opened, they're brand new. But I don't want anyone to assume or think that because somebody brings a Bible that it is in any way going to influence the court's ruling. I'm just here to listen to facts and listen to argument and make a decision. That is why I say that. All right. So you all had stepped back to speak with CPS worker?
Yes, Your Honor.
All right, so what are the results of that phone conversation?
So there is still technically an active case. The investigator does believe they're going to be closing it within the next month. As of right now, they have not set any conditions. They've also not spoken with Mr. Austin, but they've said the mother has been following everything, all their recommendations, but they do not have any conditions as of right now. And if for any findings or any of that, she did indicate she need to get back to me before giving definitive answer. But yes.
All right, so this is what is slightly concerning, and this is just based on my experience from doing CPS work. So it sounds like that's probably a family-based service plan. Is that correct or no?
That was how I interpreted it.
All right, so it's a family-based service plan, and it sounds to me as though their conditions or non-conditions is she has the children, she is not allowing the children to be placed in danger. I don't take any of these facts as true. And so therefore they're getting ready to close the case. What's concerning is they're getting ready to close the case and they're telling you they've had no contact with him or spoken to him. So I don't even know if they have factored in the closing of their case that he wants contact. So did anybody ask them about their concerns, or maybe they don't have concerns with him having contact?
So just from my understanding,
they mentioned that I believe he does not, I'm not sure if he actually still lives in San Antonio, if he's back and forth between somewhere else. So from, again, my interpretation that if he was not in the state or in a different state, those concerns didn't seem to be.
All right, so this is what I'm gonna do with regards to your motion. I'm gonna set this motion for a hearing, and if you all can have the CPS workers zoom in, usually they're good about zooming in, and these questions can be answered. Because
Okay.
I don't want to do something that causes confusion or violates orders or thoughts that they may have. So,
While I have the complainant present, does the court want to address her while she's here to avoid? I mean,
her
just
coming
to,
back, sure.
if the court has any questions for her, she is present. If the court wanted to address, if the court wanted to inquire, I'm not suggesting the court what the court should do, but
Okay.
if the court wanted to inquire, she is present today.
Well, we can go off the record. If she is present and she wants me to inquire again, this is from my experience in CPS cases. If CPS has an understanding about her allowing or not allowing contact, and that's the whole basis for them getting ready to close that family-based service case, and she comes to testify, I don't have any issues and I want him to, that may affect or impact the closure of that case. So with that being said, if she still wants to come forward, she can. But I mean, a family-based services case, depending on the actions of the parties, can quickly turn into a legal case.
Understood.
So it's completely. Do you want to talk to her, Mr. Bonk, and see,
I will, yeah.
and let her know what the possible impact could be? All right.
a quick question. Is it okay?
Oh, you probably want to speak with her.
It's
Yes.
not like that. Is it okay?
Sure.
Yeah, I live in Florida, so
Okay.
the transmute out here is really, really tough with these
Just
places.
ask Mr. Bonk, you can appear by Zoom.
That's what I was going to.
Yes, just ask him.
For
I
the-
allow
for-
people to
for
appear
the-
by
For the
Zoom.
hearing thing?
Yes,
Oh, thank you. very much.
sure. You're welcome. All right, Justin Zavala. Hello.
Morning, Your Honor. How are you?
All right, how are you doing?
Very well.
All right, let me just pull up his PSI. And his chat. All right, court is calling 2024 CR 5695 and 2022 CR 6022, State versus Justin Adrian Zavala. Can I have parties announced for the record for the state?
Neil Kalfas on behalf of Mr. Justin Zavala, Your Honor.
And are you Mr. Zavala?
Yes, Your Honor.
All right, you entered a plea of guilty and the cause number ended in 5694 and a plea of guilty to count 2 and the cause number ended in 6022 and 6022 according to the plea bargain agreement. Punishments be assessed at 6 years in the prison. The state is silent on your application and the cases will run concurrently. And in the cause number ended in 5695. According to the plea bargain agreement, punishments be assessed at 6 years in the prison. State is silent on your application and the cause numbers are to run concurrently. Have both parties had a chance to review the PSI report, state? Defense?
Yes, ma'am, Judge.
Any objections to the PSI report, state? Defense?
No, ma'am, Your Honor.
All right, defense, do you have any witnesses? The state is silent.
Judge, I don't have any witnesses, but I would like to make some arguments to the court. I did bring some exhibits. I apologize to the court for not getting those to the court ahead of time, but I'll just start off by pointing out that Mr. Zavala is currently employed part-time. He works 20 to 30 hours a week doing tattoo work just because it allows him to do his primary and his main job, which is be a father to his 2 twin daughters. He has 2 daughters that are 13 years old. They are currently attending Brentwood Middle School. They're both doing very, very good in school. He is a very good father, as evidenced by I brought some pictures just for the court to look at. essentially, he is the one that gets them up in the morning, makes breakfast for them, brushes their teeth, makes sure that they're dressed properly and that they get off to school in time. As well as does that, you know, in the afternoon when it's time for them to come home. He had the hearing was contested before a district court judge in family court, and he was granted I guess, pretty much the primary custodian.
Any objection to the court reviewing the order from the civil court? All right, so this is joint managing conservatorship, correct?
It's joint managing conservatorship, and he was given if you look at near the top, it has the duties and obligations of the mother of the children, but he was given the right to designate the primary residence for the children. And so the children were essentially placed with him and have lived with him for the better part of their lives, actually most of their lives. He additionally has a 6-month-old daughter that he sees very regularly. He's in the process of putting himself on child support for that. I brought the verification letter verifying that he's employed, if the court would like to see that.
Yes.
And then he is also.
Any objections to the court reviewing?
He's also applied and been given benefits for his daughters to help take care of those. And so I wanted the court to see some of that stuff just so the court knows that he is in fact a very, very responsible father. He's living in his mother's house currently with his daughters. He knows he's been in this court enough times in preparation for today to know the serious nature and the gravity of his circumstances. He has seen this court admonish numerous people in the past and knows what he's up against. We're respectfully asking the court to grant his application for deferred adjudication.
All right, anything you wish to say?
Your Honor, I made a mistake.
No, you did not. You made a choice.
Yes, ma'am. I made the choice and I'm going to be held accountable.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record.
Justin Adrian Zawala.
All right, your attorney has presented information to the court that you have 2 daughters that live with you,
Yes, Your Honor.
and your attorney stated that they've been living with you for a majority of their life.
Yes, Your Honor.
Then why are you making choices that put in jeopardy your ability to have them stay with you?
At the time, I wasn't thinking clearly. For the past year, it's been a little difficult for me to process a lot of things.
All right, you're speaking very fast.
I'm sorry. When I found out having a 3rd child, it was unplanned. I wasn't sure how to deal with it. I made excuses and I made poor judgment. But again, as I said, I want to be held accountable for my actions. I want to set the example for my daughters that, we make a choice, we have to deal with consequences.
All right, and if you're drug tested today, what are the results going to be?
Negative.
All right, any questions from the state? I know you're silent, but any questions as it relates to facts or no? Any questions, defense?
No, ma'am, Your Honor.
All right, just have a seat. I'm going to think on your application for a moment.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
Are you already on Bella Torres?
Yes, Judge. Good morning.
All right. So do y'all wish for a reset for you to obtain witnesses?
A PSI, Your Honor.
All right. All right, I need a PSI date on Bella Torres, please. All right, we'll be back on November 14th for PSI.
Thank you, Your Honor.
You're welcome. And probation, that'll be PSI and TAP. All right, who's here on Taj Davis? All right. All right, so there's supposed to be an update on parole.
There is, and we actually have an agreement if the court will let us amend
Yes,
his plea.
sure. Well, actually, no plea was admitted, I don't think. At
Believe
least
he entered
there's
the
nothing on the
plea.
docket sheet.
He entered the plea and the court sentenced him to probation.
Yes,
What I seem to remember.
yes.
We're asking to change that and amend it to 1 year state jail with the agreement of the state. Based on the fact that he's been revoked on parole.
All right. So then what we'll have to do. I think the easiest way to. Are there any specific violations or no?
No violations of probation, Judge. We're just asking.
It's very technical about it, Judge.
Because see, the only problem with changing his plea is that he entered a plea of no contest in July. Yes. So if you all are just asking that he be revoked, if he wants to say maybe, for example, I ordered a felony drug court evaluation. If he decides I don't want to be evaluated for felony drug court, he already was. Thank you. Look at you doing great work following the court's rulings. Yeah.
And it did say that the recommendation was for SATA.
So if he does not want to go to SATA, then a motion to revoke can be filed and then he can be sentenced to 1 year.
That's okay with it.
Because it's just that I don't have the jurisdiction to go back and do a motion for new trial and then give him 1 year. So we could do it that way. And that I think would get all parties, including Mr. Davis, where he wants to be.
He just tells you he didn't want to go to SATF, can probation then file
Oh,
the
yes.
motion right
Yes.
away?
Yes.
Okay.
I don't want to go to that.
Okay.
Okay, and we'll
I'm-
do that and then we'll come back and we have the 1 year agreement.
Yes, I'm so sorry that things didn't work out. I really thought that you were going to be on the right track. Okay. All right, so then, counsel, if you'll do the trial court certification and then probation will do the motion to revoke and then we'll go forward with it.
Okay.
All right. Yes.
On Mr. Austin, we're conferring. As far as his next court date, he set in County Court 7 impact on a trial date on October the 28th. Would the court, since he does live out of state, would the court consider allowing him to be reset for that date so we could come to, so when he's here for that case, he can also be here for your case?
Sure, they're not letting him Zoom.
Oh, that's the trial date. So
Okay, sure. What date is it?
October 28th.
Let me find his file. October, I'm sorry.
28th.
28th.
Yes, Judge.
All right, and then just, if you want to have the,
And I'll work on what you discussed.
okay. All right, Ms. Ferguson, on Austin Thomas, if you'll reset that for
James Austin.
James Austin, if you'll set that for October 28th. Oh, and Charles, be sure to let him know. I'm a Baptist. I have my Bible,
I will
but
tell. He said, sorry about the Bible. I said, okay.
no, that's okay.
He's just so tall. When he holds it,
Yeah.
you're gonna see it.
You know, I had a client who would come to court with a Bible. Well, actually, it was another attorney's client. I was sitting with them and I'm like, your Bible is brand new. Nobody, you know, but his Bible looks like it's been
Well read.
well read.
Well read. He has to be here in person anyway.
I call him the Order of Appearance Counsel.
Okay.
The MTR file.
Are you all ready for the MTR?
But they probably have to sign it and all that.
Okay.
I've heard that helps. Okay, thanks.
Xavier Martinez. Who's the attorney for Xavier Martinez? Mhm.
He picked up another thing and it automatically assigned that thing to it, which should have been, could have been another attorney on the wheel.
Mhm.
However, he did not want court appointment. So, and it says no attorney assigned.
All right, so are you the attorney on this case or not?
According to the records, no.
Okay, then you're excused if you're not the attorney.
Okay.
All right, so are you gonna hire an attorney?
I don't have money to hire an attorney.
All right, so you need one appointed?
This man.
All right, just have a seat. Norma, if you can get an attorney appointed for him. In just one moment, Ms. Ferguson. Good morning. All right, thank you for addressing appropriately for court. Today is your plea deadline date. So has an agreement been reached or you're all going to request a jury trial?
Requesting a jury trial, Your Honor.
All right, how long do y'all expect this trial to last?
2 to 3 days, probably.
All right, I need a jury trial date for family violence, 2 to 3 days.
I'm sorry, you need, I'm sorry, 2 to 3 days, Judge?
Yes. And have you all signed an acknowledgement of discovery?
I have to double check if we haven't. I will make sure that's filed and signed
All
today.
right, thank you. And my understanding, you have the EMS records and you've provided the thumb drive?
Yes.
All right.
Into November 4th.
All right, we're gonna come back on November 4th.
Okay, Judge.
Thank you.
Thank you, Judge.
Once you sign the reset form, you are excused, and just make sure the court has an acknowledgement of discovery.
Yes, ma'am.
Thank you. All right, Justin Zavala. All right. We're back on the record in 2024 CR 6022 State versus Justin Zavala, and also cause number 2024 CR 5695. So this is what I'm going to tell you. From reviewing your case and what you were up to in 6022, you really should be going to prison. The only thing that is saving you right now from going to prison is the fact that you have two children that on the civil side, they've placed them into your custody. You understand?
Yes, Your Honor.
That is the only reason. And I don't want them to be in a situation where they don't have any parent to take care of them at all. And it appears that there was no one else available to take care of them because the civil court placed you in there as their guardian and had them live with you. Do you understand?
Yes, Your Honor.
From here on out, and the defense will tell you this, you need to walk the straight and narrow, one, because you have two children who, well, now three, who are looking up to you. And they need to know what the rules are and follow those rules. Do you understand?
Yes, Your Honor.
All right. And cause number 6022, this is what the court will do. Court will sentence you to 6 years in the prison, suspended and probated for 8 years. This will run concurrent with 2024 CR 5695. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's going to be field visits until further notice. Regular reporting by Zoom or in person. Regular random UAs, or you can do the patch. The patch costs more, but the patch allows you more freedom because you don't have to sit and wait for somebody to do the UA. So I'll allow regular random UAs or either the patch. There's to be 300 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are complete, that will deduct 100 hours from the community service restitution. Probation, anything else needed with regards to that cause number?
Okay.
All right, and that cause number, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal?
Yes.
Oh, just a moment. I'm sorry, in that cause number, of course, I'm finding the defendant guilty. I'm not going to grant his application for deferred adjudication. All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
In the cause number ending in 5695, the court is finding you guilty. This will run concurrent with 2024 CR 6022. Court is going to order regular reporting by Zoom or in person, regular random UAs, ignition interlock for half the term, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits until further notice, 300 hours of community service restitution. Again, probation, the parenting classes, once that's completed, the court will deduct 100 hours of your community service restitution. Regular, and also with the regular random UAs, make sure he's tested for alcohol, but you can also wear the patch on that as well. DWI education course, DWI intervention, and the Impact Panel Live. And the court will sentence you to 6 years in the prison, suspended and probated for 8 years. And there's to be I already said field visits. Probation, is there anything else he needs? Is there anything else you need from the court in that cause number?
No.
All right, and I need your client to sign this.
Yes, ma'am.
Please. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement. Because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
And also in the cause number ending in 5695, there's to be a 2-year driver's license suspension. All right, we can go off the record. The way your children save you from going to prison is the way you need to start standing up and saving them. You understand?
Yes, sir.
Everything you do from here on out, you need to ask yourself, is this something that could potentially result in me going to prison for 6 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. And I always tell people, you should do things and want to be better for yourself. But if you don't want to do it for yourself, do it for your children. You understand?
Yes, sir.
And this court, communication is key. If there's an issue, let your probation officer know about it. If you feel as though they're not addressing it, you can always come back to court. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you, Judge. May I be excused?
Yes, thank you.
How many fees my defendant has?
All right, Taj Davis. Oh, I'm sorry, I need to see that.
Yeah.
Yeah.
I just need to see it, or do you want them? I mean, after everyone agrees.
All right, court is calling 2024. Just one moment. Okay, I see the file on Taj Davis. I don't have that up here. Okay. Sure. Thank you. All right, court is calling 2024 CR 5909, State of Texas versus Taj Davis. Can I have parties announced for the record for the state,
Yes.
for the defense?
Can we?
And are you Taj Davis? Are you the same Taj Davis who was placed on deferred adjudication in cause number 2024 CR 5909 for the offense of evading arrest, detention with a prior conviction on July 9th, 2024 for a term of 4 years? Is that you?
Yes, ma'am, it is.
All right, state.
Violating condition number 14 AA on or about the third day of October 2004 in Bear County, Texas. Randall Davis given their bill to comply with the rules, regulations, and instructions of the Bear County Community Center Department of Treatment. On further to incarceration program that we follow all recommendations, violations.
How do you plead to that? All right, so everyone, we're on the record. Don't talk behind the court reporter. All right, did you understand by pleading true to violation of condition 14 AA, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of 14 AA? Court will find violation of 14 AA true. Is there a proposed agreement?
There is, Your Honor, and I just want to put on record that I believe that defense counsel and defendant are waiting those 10 days to prepare.
Sorry.
We are, Judge. We've discussed it. He understands that he'd like to go forward today. We've looked at all the evidence, everything on the record, and would still believe that this is the right thing for him to do.
All right, do you wish to proceed?
Yes, ma'am, I do.
All right, the court is finding 14 AA true. Is there a proposed agreement?
There is, Your Honor, and it is to revoke the individual off his probation and sentence him to 1 year in the state jail facility.
And is this running concurrent with anything?
That is right.
With his parole, Judge.
All right, do you have the trial court certification?
I filed it.
Sorry, Judge.
That's okay. All right. So what I can tell you, normally I would follow your agreement, but the court will note that he was prepared to proceed with all the conditions of probation. The issue was the parole issue. And I do believe that he needs help with drug issues. And I note that each time you would come to court, you would appear healthier, right? So this is what the court is gonna do. The court is gonna grant your motion, find you guilty. This will run concurrent with parole, and the court is gonna sentence you to 180 days. Does he have 180 days in?
It does, Judge.
180 days in the state jail facility, give you credit for any time served, and the court will note that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what those are, you need to speak to an attorney. You understand? All right, we can go off the record. I regret that you were not able to do the program. I know that you were ready to get the treatment. Felony Drug Court had interviewed you. They were going to take you. So here's the thing. Whenever you are released, if you can't find a place for a treatment, you come back here. If I'm still here, I'll direct you to a place, and I'll still direct you to Felony Drug Court and ask them to work with you, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're
Thank you,
welcome.
Judge.
Thank you. God bless you too.
Martinez,
Enoch Segundo.
Martinez Xavier.
All right. So where are we on this case with discovery?
We have discovery, Judge.
State, were you able to tender an offer?
Yes, Your
All right, sir, how old are you?
19.
All right, so I'm going to set this for November 4th for a plea deadline date.
Judge, could we possibly skip over some of those steps? We'd like to ask for a speedy trial. He's been in jail for almost 8 months on a state jail case with no prior convictions.
Okay.
We'd like to resolve this matter.
All right, Norma, can you put this on the jury trial docket for November 4th?
Yeah.
All right,
Thank you.
thank you. You'll be brought over dressed for trial in whatever clothing you have. If you wish to be dressed in something different, you'll need to do a clothing exchange. All right, thank you.
Segundo.
And Raymond, if you'll get an acknowledgement of discovery signed, please.
I will do. Yes, I'm making it.
There was a few Monday.
All right, who is here with the interpreter? Hi. All right. And if you have your client come down. What is your client's name?
David Estrada Nava.
David Estrada.
También. All right, 162, 2 more days.
Clerk, you have David Estrada? Ah, I found it. Thank you. All right, court is calling 2024 CR 009-719. State versus David Estrada Nava. Can I have parties announced for the record for the state?
Andrew Harrison.
Defense,
Ruben Flores. Mr. Nava. Estrada Nava.
and are you Mr. Estrada Nava? Yes. And I see we have an interpreter. Could you raise your hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, can you even lower your hand if you'll state your name for the record?
Carmen Tarragona Gonzalez.
And are you Mr. Estrada Nava?
Yes.
All of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
And counsel, do you speak Spanish?
Yes, Judge, I am fluent.
And do you speak it fluently?
Yes.
And were you able to speak with your client in Spanish?
Yes, Judge.
And were you able to go over these documents in Spanish?
Where's Judge?
Mr. Estrada, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Nava, did you review the document entitled Court Admonishments with your attorney?
Yes.
Did you understand it?
Yes.
And did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with evading arrest, detention with a vehicle as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court would find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Estrada Nava, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No. No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
I'm in an immigration process.
So are you a citizen? Yes or no?
No.
No.
All right. Counsel, has your client had an opportunity to speak to an attorney regarding the impact this plea will have on his immigration status or the immigration process that he currently is going through?
Yes, Judge. He has a lawyer on his immigration.
All right. Mr. Estrada Nava, have you spoken to your immigration attorney regarding the impact this plea will have on your immigration status?
Yes.
Do you understand the consequences of entering into this plea as it relates to your immigration status?
Yes.
Do you understand that you could be deported from the United States and not allowed to re-enter?
Yes.
Did you understand that you could be denied naturalization or citizenship?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargaining agreement, punishment is to be assessed at $1,500 fine. and the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counselor, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a cap evaluation, 120 hours community service restitution, no harmful or injurious contact with Christina Bernabe, Bernabe, Maldonado, and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
No objections, Your Honor.
State, you may be excused. Did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
With the court's permission, Judge, yes.
Anything you wish to say on behalf of your client?
Judge, we simply ask the court to follow the plea bargain. He's gainfully employed once he gets out of here, and he intends to comply with all aspects of his deferred adjudication.
All right. Anything you wish to say, sir? When's the last time you had employment?
The 22nd, which was a Saturday, June 22nd.
All right. And do you have any children?
Yes.
How
One.
many?
One.
Age?
9 años.
9 years old.
All right, this is what the court is going to do. Court is going to sentence you to 6 years deferred adjudication, $1,500 fine to be probated, regular reporting by Zoom or in person, regular random UAs, no contact with Christina Bernabe Maldonado, anger management, 120 hours of community service restitution. I'm going to order parenting classes with compadre y compadre. Once that's completed, the community service hours will be deemed satisfied. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Are you in the United States legally? Okay, I'm going to take that as a no.
Judge, he's in the process of applying to gain status, and he does have a hearing date for later this year.
All right, so he's not allowed. He's not allowed to be in the United States illegally. That's a part of his conditions of probation. I'm gonna order a TAP evaluation. And that will be in custody. And follow all TAP recommendations. All right, probation, is there anything else he needs? Oh, thank you. Field visits. One time per month until further notice. All right, is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. I have no authority to deport you, but what I'm telling you as a condition for your probation, you cannot be in the United States unless you're here legally. If you are in the United States and you're here illegally, a motion to revoke will be filed. Do you understand?
Yes.
All right, if you need anything, let probation know. If you feel as though they're not addressing it, you can address it with the court. Good luck to you. All right, who is here with, thank you so much. Thank you.
My pleasure, Your Honor.
Yes. All right, this is the last case I'm taking up before we do our break. And I believe there's someone here with witnesses, or is this Stephen Raleigh?
Yes, sure.
All right, so I'm going to take that case up because you all have witnesses here. You have victim impact? All right, let's take that up. Stephen Allen Raleigh.
Morning, Judge.
Good morning. Oh, afternoon, yeah.
Just barely. And we have one witness brief.
Okay. Court is calling 2024 CR 006879, State of Texas versus Stephen Allen Raleigh. Could I have parties announced for the record for the state? Defense.
Brandon Lopez for Mr. Riley.
And are you Mr. Raleigh? All right. Have both parties had a chance to review the PSI report? State?
Yes.
Defense?
We have, Your Honor.
Any objections, state? Defense?
No objections, Your Honor.
All right, according to the plea bargain agreement, you entered a plea of no contest to count 1 and count 2. And according to the plea, punishment is to be assessed at a cap of 6 years in the prison. The state is silent on your applications. There's an affirmative finding of a deadly weapon, and the state is taking some cases into consideration, and there's to be restitution to some of the complainants. All right, state, do you have any witnesses? Defense, do you have witnesses?
We have one witness, Your Honor.
All right, you may call your witness.
Defense calls Aaron Zamora.
Yes. Cap of 7. Oh, okay. In case I did, it's a cap of 7. All right. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
I affirm, yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Aaron Zamora.
All right, defense.
Mr. Zamora, how do you know Stephen Riley and his family?
I know Stephen and his faithful mother, Sister Riley, through Church of Christ, Wall Street Church of Christ. She has been a faithful member, attending twice on Sundays and on Wednesdays, and Stephen has also attended. I was surprised. That's how I know him.
And so you're a minister at the church?
Yes, one of the ministers.
And when you heard about the charges that were leveled against Mr. Riley, were you surprised?
I was very surprised.
And why were you surprised?
He's known the gospel. He's a Christian. He has been baptized back in about 12 years old or so. He knows what right and wrong. I think he was foolish in what he did. He was a stupid act. He didn't realize. I don't think he realized the impact of his actions.
Speaking of the impact of his actions, obviously it impacted the victims, but how has that also impacted Stephen's family?
He lives with his mother. He has a son. His son's mother works, so the little guy stays with Sister Shirley. She is disabled. She's on a walker, and so he assists her with taking care of the little boy and helping her with getting her medications, going to the store. So he has a positive impact at the home.
And now, Stephen's mother, Mrs. Riley, asked you to be here as a spokesperson of the family, correct?
That's correct.
And as that as that spokesperson, what is the family asking the court to consider?
I would say he knows the Bible. He knows what's right and wrong. I think he was a foolish. He acted out of foolishness, not realizing the impact. I'm sure he's regretful. He's sorry for his actions. And so I know he's been already incarcerated 6 months or so. I would say mercy, and I don't believe he's a returning offender. I don't think he's had prior such cases like this with him. Mercy and opportunity to show his regretfulness, opportunity to show that he can be a positive role model in the community. I personally, as a minister, I'm going to get as a mentor, be there for him, and be able to maybe teach him more about the right, wrong, what the Word of God says when we encounter difficulties in our communities, violence, etc. Act in an appropriate Christian way.
Thank you, Pastor. Pastor Witness.
Any question?
Sir, were you familiar with the underlying facts of what happened here?
I'm familiar that he pulled out a gun and discharged it up in the air.
Were you familiar that it's also alleged that he was pointing the gun at people when he was pregnant?
I think he was waving the gun, for my understanding.
But again, the stipulations that are with the judge right now, they show that he pointed the gun. Are you aware of that?
Not pointing directly to a person. I don't think he would be foolish enough to point and to shoot at someone. Probably waving it, probably.
So again, you weren't there.
Nope.
But you're all just hearing the second hand of the ones.
Yes.
Nothing to say.
All right, any other questions?
No other questions, John.
Thank you so much
You're
for
welcome.
coming in.
Yes, ma'am.
All right.
Thank you, Judge.
So, if you come forward. All right, so this is what I'm reading in the PSI report. And it's with regards to the complainants. And they're saying that they're okay with him being given probation. They just don't want him around them anymore. Did I misread that?
That is definitely one of the impact statements, Your Honor, but I believe there's a secondary one.
Yes, sir. I believe there's a secondary one.
Okay,
Be on page 4.
page 4. All right.
Other than argument, Your Honor, if at an appropriate time.
Okay, I'll
No other
hear,
witnesses.
unless there are other witnesses. All right, the court will hear argument.
Your Honor, we're here today. Mr. Riley is taking full responsibility for what the events that happened. In various discussions with Mr. Riley, he's characterized this as the worst day of his life. He obviously reacted in the worst possible way. He put himself in danger. He put other people in danger, namely the victims. And as a result, he's been here for 6 months. He's never spent any extended amount of time incarcerated. He's from Alabama, but he's lived in San Antonio for about 15 years. Again, he has no previous felony convictions. His highest level of education is 10th grade. He's always had steady work, whether it was Home Depot, Sam's, Chili's, and most recently acting as a security guard 3 months prior to this event. He does primarily take care of his child, the 3-year-old who lives with him and his mother. These last 6 months, he's been unable to provide. He's been unable to visit them. We had motions to reduce bond. We got those reduced, but they still couldn't come up with the money. So he's been here thinking and obviously regretting his actions and hoping and praying for an opportunity to prove to the court and prove to the state of Texas that he is capable of being a law-abiding citizen, to be monitored, and to follow the rules of this court. We are asking for deferred adjudication, Your Honor, and that opportunity.
All right, so what the court doesn't understand, I don't understand how you confronting a neighbor because they had called the police. One, I don't understand why you would go confront them, but I don't understand how that turns into the drawing of a gun. Somebody get me to that place where a complainant has called the police, whether you think they called the police numerous times, rightly or wrong. How do we get to the point where you're charged with aggravated assault with a deadly weapon? How does that escalate to that point?
Your Honor, it's my understanding, and if you want me to answer or you want him to,
Sure.
it's my understanding that there was a feeling of being threatened, and there were several neighbors that were, gathering around him. And again, I think that it's good to preface this with right or wrong, and I think in this case, wrong. He brought a gun out, and obviously it led to where we're at. That was as poor of a judgment call as possible. Mr. Riley has relayed the same to me, and it led to here.
Okay. All right, and I do understand two of the complainants are saying they want him to have deferred adjudication. One complainant is saying they don't want him to have deferred adjudication. So I do take everything in consideration that I'm reading. The first complainant is saying, send him to prison, because then they'll be assured that at least while he's in prison, they won't be back to the apartment, right? So if I were to send him to prison, I don't think people understand about the length of time that people are actually staying in prison. He would be eligible for parole within 3.5 years. If I were to place him on deferred adjudication for 10 years, then he would be under the court's supervision for 10 years, unless I decided to, of course, if I'm still here, unless I decided to revoke him, or unless I decided to terminate him early, he would be under the court supervision for 10 years. He could be on GPS and not allowed to go to that location. So I'm balancing the weight of what the complainants are requesting, and I'm looking at his criminal history. And his criminal history is really not his criminal history consists of possession of a marijuana, where he received 6 days in the Bexar County Jail. Then we have this. So I'll hear argument state.
State is silent.
Yeah.
I will say though, Judge, that again, based off stipulations, again, he brought a gun to where no one else was armed. He also shot at the police were approaching stipulations. Again, danger to the community, this is an argument between neighbors with just reported it as that was what the issue was.
All right. Defense, the state is silent other than fact issues. So is there anything you wish to add?
I don't think there's anything further to clarify, Your Honor.
All right. So this is what I'll do. Mr. Rowley, I can sentence you to deferred adjudication, in which case it will be for the full 10 years. You will not be released from the Bexar County Jail today, because I will be sentencing you to ISF, or I can sentence you to 5 years in the prison. Those are your two options.
ISO. I'll tell you ISO.
All right. And then I see that there was a request for mental health evaluation as well. So we do have mental health issues that are happening in this case as well. And until we can have placements for people who have mental health issues, this is the only thing that the court can do. So the court will sentence you to 10 years deferred adjudication. And counsel, normally I don't do this, but he does need to pay the $1,000 for the family moving. So there's going to be $1,000 restitution. And that's to Frank Hernandez. You're not allowed to go on the streets of that apartment complex. So there's to be no contact with the Conley Apartments at 5300 Northwest Loop 410. There's to be regular reporting by Zoom or in person. There's to be ISF cognitive, proof of employment within 30 days of release, no employment as a home healthcare provider or with minors, anger management. We're gonna do GPS, waive fees. And that will be for tracking. That way we'll know where you are at all times. You understand? There's to be regular reporting. Sorry, I already did regular reporting. There's gonna be field visits, one time per month until further notice. 200 hours of community service restitution. I'm gonna order parenting classes. Once you completed parenting classes, that will be deemed satisfied. There's to be no unsupervised contact with minors. Taking consideration 2024 CR 006874, 2024 CR 006881. No contact with Frank Hernandez, Frank Coronado, Lily Beth Huerta. I'm sorry, Huerta. There's a $2,000 fine that will be probated. And counts 1 and count 2 will run concurrently. Let me see what the TAP evaluation says. And there's, upon release, there's going to be 90 sober meetings in 90 days. Probation, is there anything else?
Judge, did you mention UA?
Thank you. Regular random UAs or the patch? Anything else, probation? Is there anything else that you need? All right, did you review the document entitled Trial Court Certification of Defendant's Rights Appeal with your attorney? Did you understand it and sign it? Sorry? Because this is a plea, because I followed your plea and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And you're not allowed to possess any weapons or ammunition. Do you understand? All right, we can go off the record. Here's the thing. If you are revoked off this probation, you're looking at 20 years in the prison. Do you understand? Not a cap of 7, but 20. Do you understand? All right, good luck to you. Just stand over the side. I believe there is victim